Hi, I'm attorney John Mangan, a Florida Bar board-certified attorney in the area of wills, trusts, and estates. And I often get questions from clients and from others about what's involved with the probate process. So this is another one of our videos about that entire probate process. Here today, what we're going to focus on is distributions. So distributions primarily being made to the beneficiaries of the estate. So when we get to the point where we are contemplating distributions, typically, by this point in the process, the personal representative, who's often our client, has identified any creditors who have valid claims against the estate, and those claims have in fact been paid. Assuming that that has happened, the first thing that the personal representative needs to do is to make sure to set aside some funds in a reserve. So there are going to be some final expenses and costs involved with this process, things like paying the IRS or any other governmental taxing authority if they haven't been paid yet. There will also be costs associated with attorney fees and anything else that might be necessary to actually get the estate closed. So you want to make sure that talk to your attorney, set aside a reasonable amount in a reserve fund so that you don't run out of money when you start making these distributions. Now, when it comes to distributions, there are two primary types. The first one is what we sometimes refer to as a specific distribution or bequest. So this would look something like, upon my death, I leave $10,000 to my niece. So it's a fixed dollar amount and it's just a one-off gift. So these gifts are typically going to come first when we start making distributions to the beneficiaries. So that's one version of a specific gift where we have a finite dollar amount. The other one might be when there is specific property that is earmarked for a certain beneficiary. So for example, I leave my condo to my daughter, right? There is one specific type of property, or maybe it's an account that is left to a specific beneficiary or beneficiaries. So that's the other type of specific bequest or gift that we often see. Once those specific gifts have been satisfied, next we move down to what we would call the beneficiaries of the residue. So the residue is everything that remains after we've satisfied those specific bequests. And so if there's a will in place, then we'll typically see shares listed in there. It may be an even split between adult children, but not necessarily so. If there was no will, then we're dealing with a situation where our statutes are going to govern who receives what and in what amount. So you want to make sure that you check with your attorney and you know exactly who is supposed to receive from the residue and how much. So what I've just been describing are sort of final distributions when we are getting very close to wrapping up the estate. Occasionally, there may be interim distributions that are requested and the attorney may sign off on. So for example, especially if we have an estate that's taking a longer amount of time to settle, there may be requests from beneficiaries, something along the lines of, hey, could I get something right now? Maybe get 10% or a quarter of what I have coming to me. That may be possible. Make sure you check with your attorney if you're the personal representative on this. So to the extent that any interim distributions have been made earlier in the process, when we come to final distributions, obviously you want to take those into account and subtract those out from whatever share that beneficiary is supposed to receive. So that's just an overview of the phase of the probate process where we are making distributions to beneficiaries. If you have any questions that are specific to your situation, please feel free to reach out to our office. We're here to help, and we look forward to hearing from you.